All right. So everyone in the chat, thanks so much for joining us today, both at the Canadian Immigrants Conference and at Boris's session for employment rights in the workplace. So Boris, I'll give you guys some background on Boris. So Boris is a Toronto employment lawyer and associate with the Samfiru Tumarkin LLP's Labor and Employment Law Practice Group. And prior to joining Samfiru Tumarkin LLP, Boris articled at a top tax litigation firm in Toronto, Ontario, and worked as an associate in an employment and labor firm in Vaughan, Ontario. So, Boris, you're going to be covering employment rights in the workplace today, which, super important topic for a lot of newly landed immigrants, because, I'm a first-generation immigrant myself, so I know that a lot of people who have just come to Canada are not really familiar with the labor laws here. So definitely something that's important to talk about. So I'll let you take it away from here. And I'll come on at the end of the session as well to kind of close it out and let everyone in the chat know what's coming up next. All right?
Sure, sounds good. Thank you, Jesse.
All right, thanks so much.
All right, guys, welcome to my presentation for today. As Jesse mentioned, I'm going to be talking a little bit about employment rights. Now, employment rights is quite a vast subject here, and I won't be able to cover everything. So if you guys have any questions, anything in particular, if you have a specific situation in mind that you're thinking about, just type it away in the chat box, and I'll try to answer that as quickly as I can. Now, if you have any questions about something that I'm discussing from my presentation, then just, again, feel free to send the question in the chat box, and I'll make sure to respond to it as quickly as I can. So, now I am going to start the presentation. You're going to see a little bit of my bobblehead over here, and I'm going to be moving it with each slide just so you can see everything, okay? So, to start, the presentation will be about employment rights in the workplace, and we're going to be talking about employment contracts, workplace harassment, duty to accommodate, and termination rights. All very important things to understand if you're looking for a job. Now, let's talk a little bit about the firm. So the firm that I work for is Samfiru Tumarkin LLP. So we do primarily two areas of law. So we focus on labor and employment, and we focus on personal injury and disability. Now, with respect to labor and employment, there's numerous areas that we can assist with, and particularly that I can assist with. Now, something of interest that you guys might enjoy is that our firm is the largest Canadian employment law firm, and we also are known to have the most reviews of any firm throughout Canada. And we have 4 offices, one in Toronto, one in Ottawa, one in Vancouver, and one in Calgary that we recently opened, which is why there's only 10 reviews, but all of them are 5 stars. Now, we're also familiar with a lot of media partners. You can find us on radio shows, TV shows, and the news online. So if you're ever looking for some information with respect to employment law, disability law, injury law, labor law, you know where to find us. Now, a little bit about me. This is me with much shorter hair. So I immigrated myself from Belarus and into Canada when I was 5 years old. My undergraduate degree is from York University in criminology, and then I went to Queen's Law for my law degree. I have experience in international business law as well as tax law, and currently I'm an employment lawyer. And in terms of my personal interests, I enjoy traveling, filmmaking, and learning languages. Now let's talk a little bit about employment contracts, okay? So if you're ever interested in signing an employment agreement, there's a few things that you need to be aware of, especially if an employer is trying to get you to sign something on short notice, okay? There's a few key provisions. There are the hours that you're going to work, pretty simple. The duties that you're going to be responsible for. The compensation, which is how much you're going to get paid, and in what type of structure, if let's say it's commissions or bonuses or anything of that sort. The term of employment. Now, sometimes an employee may be hired to work for just a year or for 6 months, for example. And sometimes the employee is hired to be working for an indefinite basis until the relationship ends by either a resignation, quitting, firing, or anything of the sort. Then we're going to be talking about probationary clauses. For example, you might see this in an employment contract where it says, we're going to essentially test out whether you're a good fit for us for 1 month, 2 months, 3 months. Typically, you don't see it for longer than 6 months, but even that's quite a bit. Okay. Now, if you see a probationary clause, it's very important. If it's 3 months, you have to understand that if you're not the right fit, they can just terminate you for any reason whatsoever, and they do not have to pay you anything. That's their fail-safe. And then, of course, something that's very important, the most important for us, is the termination clause. We'll talk a little bit more about that in this presentation, but something to realize is that if there is a termination clause, make sure you understand what it means. If there isn't, it's actually kind of good for you. Now, another one that you guys might see is something called a non-compete clause. A non-compete clause pretty much says you are not allowed to work for somebody that competes with your former employer if you leave. Now, sometimes these can be for a month, a year, 2 years. The longer it is, the more harsh it is, and the more likely that they can't actually do that. And lastly, I think the most relevant one for today's world is layoffs. During the age of COVID, a lot of people are getting laid off. And the question is, can they do that? And if they can do that, for how long can they do that? What options do you have? Really important for you to understand the layoff provisions. Now, let's talk a little bit about human rights. Now, you guys might have heard this term, and it's kind of all-encompassing. First of all, one thing that you might want to know is that if the human rights are based on a piece of documentation, legislation created provincially within Ontario and federally within Canada. For our purposes, let's focus on Ontario because presumably that's where all of us are going to be. Now, if you're ever curious about what the whole document says, it's pretty simple to read. It's not too confusing. And all you have to do is just search up the Human Rights Code. Now, what does the Human Rights Code present? You have to be treated fairly and equally. And your job protection is when you are applying for jobs, while you're working, and even after you're terminated. Your human rights still exist. Now, your human rights will be protected even if you are a full-time employee, a part-time employee, an intern, temporary, casual, or if you're on a contract basis, such as an independent contractor, for example. Like, let's say if you're an Uber driver. Now, you cannot be discriminated against for many, many things, such as your age, disability, citizenship, race, place of origin, and so on and so forth. You can see the list there, but a few things that I want to focus on is that for those of you that are new immigrants to the country, or for those of you that are unfamiliar generally with respect to your human rights, it's important to understand that regardless of where you come from, regardless of who you are, what you look like, who you love, and who you're with, however many kids you have, and even if you went to prison, you cannot be discriminated for any of those things. Now, what happens if you do? All you have to do is show that at least 1% of the reason for your negative or unequal treatment was because of one of those above reasons that I listed. So that's how we can facilitate a human rights violation. So something else that's important for us to discuss is this duty to accommodate. Now, when it comes to accommodating, you might wonder, well, what's the limitation here? And what can I actually receive that will help me out? Well, let's talk a little bit about it. What is the duty to accommodate? So the duty to accommodate is to ensure that everyone that can work is able to do so. Now, if let's say, for example, you have some sort of an injury, and now you can no longer work a certain element of your job. Well, that would fall under, let's go back here, one of the protected grounds, disability, right here. So if that happens, then they have to accommodate you, they being the employer. So, for example, if let's say you have a back injury that prevents you from lifting heavy in a warehouse, well, can your job be done without having to do that? Can you be placed into a position that allows you to do your job or to do a similar job without lifting heavy? Well, then they have to accommodate you. Now let's look at some examples of accommodation, okay? You can be accommodated with a change in your schedule, and especially today, in today's world, remote working. If let's say your job can be done remotely and you have a situation where kind of like today, Premier Ford says, you know, if you can work from home, then the employer should let you work from home. Well, that's a method of accommodation. And for example, let's say if there's a policy in the workplace that discriminates against an individual for some reason, to remove that. And let's say if you need to go to the doctor, allowing time off. So these are not the only forms of accommodation. There are many other forms of accommodation that you can receive, and it just depends on what kind of accommodation you need. So what's important to know is that it's on a case-by-case basis. But it's not limitless. You can't just receive an accommodation for anything and everything. Let's look at an example that I have here. What if you are a pilot and you are injured in the workplace or outside of the workplace, and now you can't see from one of your eyes? It's a little bit difficult to re-employ somebody who's a pilot into a non-pilot position, especially if that's what they're trained in. In that case, it would be considered unreasonable, or it would be considered too difficult, causing too much hardship for the employer to do that. Because in that case, what would happen is the employer would essentially be paying you to not do the job you were hired for, and they have nothing else to offer you, so you're just on their payroll as an employee, and you're not helping them in any way. You're not benefiting them in any way. You're effectively not even an employee at all. So, most important, guys, if you ever need any form of accommodation, do not wait. Go to your attending physician and get a medical note of some kind. And in the medical note, you want it to be as detailed as possible. You want to make sure that the physician outlines what is the injury, what is the disability, and then talk about what are the limitations, what can you not do, what can you do. And lastly, you want to talk about accommodations. Okay, if you can't lift heavy, what can you lift? Can you lift 5 pounds? Can you lift 10 pounds? Can you run? Can you walk? These are all the things that would be super helpful for you to get the type of accommodation that you're looking for. And then, while this is not as necessary, oftentimes employers tend to ask, well, okay, fine, we'll accommodate this employee, but how long do we have to do it for? So if your physician has a timeline in mind, then that's what they can reference, or they can say, in X amount of months, we're going to reassess the situation. Let's talk about duty to accommodate a bit more. One of the most important things is that let's say you get injured and you need to take a leave of absence. Or let's say something really terrible in your life happens and you need to take a leave of absence. Well, maybe 2 months have passed, maybe a year has passed, maybe a short period of time has passed. Do you get your job back? Can you get your job back? Are you guaranteed to get your job back? Yes. You have a right to return to work, okay? What that means is that you have a right to be returned to your original job. For example, and I see this all too frequently, if an individual takes a pregnancy leave, well, first of all, they're protected based on their human rights to take that pregnancy leave and to not be discriminated for taking that pregnancy leave. Now, 9 months have passed, and sometimes with the maternity leave, 18 months have passed. And then what happens? Do they get their job back? Well, sometimes employers replace them, which is bad, or they decide to fire them before their return, which is also very bad. So what happens is that they have a right, an obligation to return this individual back to the position they held. They cannot make it conditional. For example, sometimes what I see is an employer says, if you provide us a medical note that confirms that you do not have this illness anymore, or if they say, you will return to work if you accept a demotion in hours or pay, that is not allowed. That's breaking the law. Okay? You can't accept a conditional return to work, and they're not allowed to offer you one. But let's say by the time you're able to return to work, your position isn't available anymore for one reason or another. And let's call it a reasonable reason. Well, the employer has an obligation to discuss with you alternative work possibilities. Like, let's say, for example, you can return to work, but they don't have the exact same position anymore for one reason or another. If they can offer you something similar that still pays you the same, your hours would be the same, your shifts would be the same, that's a reasonable response to the duty to accommodate. And one thing that's most important is an employer cannot assume you are incapable of working. And that follows up on what I said earlier, where a return for a disability cannot result in a demotion in duties and pay just because the employer thinks, they just came back from some type of surgery, there's no way they'll be able to do this anymore, I'll put them into somewhere else and I'll pay them less. Essentially, that's why the physician note is so important, because the doctor's note will explicitly outline what you can and what you cannot do. Let's continue. But with that being said, the right to return to work is not limitless. Like I said earlier, the employer is obligated to keep the job available, but if, let's say, you take 5 years off from work, that might be a bit of a stretch. Maybe your job's no longer there. Maybe it's not reasonable for them to have kept you on the payroll. Now, let's talk a little bit about workplace harassment. So the workplace harassment information comes primarily from a piece of legislation called Occupational Health and Safety Act, OSHA. Now, there are many forms of harassment, and of course, some elements of this are subjective, but throughout the courts, there have been objective methods of harassment, such as inappropriate physical contact or violence, remarks that discriminate you based on the human rights that we discussed earlier, such as your age, your sex, your gender, relationship, religion, anything of the sort, threats, and intimidation or unprofessional responses from either the coworkers, your managers, or anything of the like. Now, one of the things that you might hear often when you read about workplace harassment is this concept of toxic. Now, toxic in the sense of legal refers to wherein an employer is aware of harassment, discrimination, or bullying in the workplace and either chooses to not address it or actively participates in it. You'd be surprised how often employers, your bosses, supervisors, managers, would actively be participating in the same ostracization and harassment that is frustrating you. So what does an employer have to do? Well, first of all, they have to ensure that the environment you work in is free from harassment. So if harassment does occur, they have to take action. For example, they have to conduct an investigation, they have to prepare a report, and they have to ultimately solve the issue. But keep in mind, they don't actually have to disclose the report. It would be in their best interest to do so, but oftentimes you see them not actually doing that. So, key tips to remember based on what I've said thus far. If you are experiencing any form of harassment or discrimination, always diarize it. Write it down somewhere. Ideally, shortly after or at the same time as it's happening. Write down the date that something happened, who said whatever they did, and the details that you could remember. Trust me, that'll work in your favor at the end of the day. Next, report it to human resources. Make your complaints and concerns known. I understand that a lot of people might be intimidated to do that. Maybe they're unsure of how to go about it. Maybe they'll feel like they'll be punished for it. Well, guess what? If you're punished for bringing forth a concern or a complaint, there's a response to that. There's a legal response to that you can be protected by. It's called a reprisal. So don't be afraid. Don't be shy. Make your complaints known, because if it keeps happening in the future, it's going to benefit you to have made these complaints. And a lot of times, I hear employees telling me how they had all of these conversations where human resources or your manager or supervisor said this or said that, but there's no proof. And then it just turns into a he said, she said situation. So here's what we do. You follow up conversations with an email confirming the topics you discussed. So that way you can ensure that there's no miscommunication. So now let's talk a little bit about the difference between a wrongful dismissal and a constructive dismissal. Now, a wrongful dismissal is when you are terminated, but you're not given the right severance pay. It doesn't mean that you were wrongfully dismissed because they gave you a bad reason or they terminated you for some unknown reason. No, they don't actually have to tell you what the reason was, nor do they actually have to be honest about it. A wrongful dismissal simply means you did not get the severance package you should have. Now, let's talk a little bit of constructive dismissal. A constructive dismissal happens very frequently, and it essentially means when an employer makes a fundamental change to your employment contract. Now, for example, if you're working 40 hours a week and they say you're now working 20, constructive dismissal. If they say you're working in Markham and then they say you're working in Ottawa, constructive dismissal. If you're a supervisor, now you're an intern, constructive dismissal. And recently, the one that's been the most frequently occurring nowadays, layoffs. If you are temporarily laid off, it's a constructive dismissal. Don't let anybody tell you otherwise. Now, lastly, another form of constructive dismissal, but the one that's least successful on its own, if you have one of those toxic work environments that I talked about earlier. So, one thing to remember, if you are laid off, for example, and you accept the layoff, that can now happen again and you do not have the same legal background that you can rely on. If, for example, you get a demotion, a salary reduction, and you say, okay, that's fine with me, that can happen again, and you won't be able to argue that when it happened originally, it was an issue. So be mindful of it, reject it, and if they carry on anyways, contact a lawyer. So let's say you're terminated. What's your severance package? How do you get paid? What do you get paid? Let's find out. So if you are non-unionized, you're generally entitled to some form of a termination package. Now you can receive the pay in one of three ways or a combination of them. Working notice, which means you are continuing to work and that encapsulates your termination pay. For example, if a company says you're terminated, you're being told you're terminated today, but your end of termination is March. So that timeline, that interval, is your termination package. Salary continuance, where you're not employed anymore, but they pay you according to your payroll. So according to the bi-weekly, bi-monthly, and so on and so forth. And then lastly, you can be paid as a lump sum, which most people oftentimes prefer. Now, it's important to understand your minimum entitlements cannot be conditional. Oftentimes, when you receive a severance package, you're also going to receive something called a release. And the release outlines what you will receive in exchange for giving away certain rights of yours. Now, if a termination package says to you, we'll give you your minimum entitlements if you sign this, it's not allowed, it's illegal. And your severance pay cannot be paid with a working notice. More on that right now. So what are your minimums? What are your guaranteed rights? Well, those are found in the Employment Standards Act, which is otherwise known as the ESA. So, to put it simply, you receive minimum 1 week per year of service up to a maximum of 8 weeks. That's what you have to be given, regardless of whether lawyers are involved, regardless of what you're doing, what your employment is, and so on and so forth. You have to be given that. And under certain circumstances, you may be entitled to an additional amount up to a maximum of 26 weeks. Now, what are some things you have to be given if you're terminated? Well, you have to be given the minimums, which is known as the pay in lieu of notice. You have to be paid any type of money that you accrued and vacation that you accrued up to the date of your termination. If you have group benefits with the company, you have to have a continuation of benefits for the same period, whether it's 1 week, 2 weeks, up to a maximum of 8. And if applicable, you have to be given your severance. But there's a limitation. The limitation is whether there's an enforceable termination clause, but that requires the review of a lawyer. But if you don't have a termination clause, or it's unenforceable, that's awesome. You get to use common law, which almost always guarantees that you will get substantially more than you expected. So, common law, what is it? It's judge-made law. Anytime a judge sees a particular individual with certain factors, they assess that, it becomes precedent. So what do they rely on? Your age, your position, how long you were with the company, what was your salary, and how difficult it might be for you to find reemployment. Those are the primary factors to rely upon. But these are determined on a case-by-case basis. For example, if you're a cashier, you've been working for 2 years, you were making minimum wage, and you're 25 years old, you're probably not going to get more than maybe a month, a couple weeks at best. That's because it's quite easy for you to replace that income, that position. You're still extremely young. There are dozens of cashier positions available, and you haven't been working so far that you're away from any type of networking opportunity. But then conversely, what if we look at an engineer who is professional, 20 years of employment, making $120,000 and is 50 years old? Well, they might get somewhere between 18 to 24 months because it's probably going to be very difficult for them to find another comparable job. But then let's look at something like this. We have a truck driver, and there are numerous truck driving positions available. Finding a position for a truck driver after you're fired is not difficult. But let's say they were working 12 years, $80,000, 45 years old. So now you have these numbers that are up there, but you have a very replaceable job. Add a disability into the equation. What if all of a sudden your doctor indicated that due to a recent concussion, you can't be driving? Well, that increases the amount of severance that you're entitled to and might get you to that similar vantage point of around 16, 17, 18 months because there's no way you can find another job similar to that. You can't drive, right? So things like that are also taken into the equation. So what if you're terminated with cause? So if you're terminated with cause, you're not entitled to receive any type of severance package. And you also may not be eligible to receive employment insurance. It's considered quite literally the capital punishment of employment law. But what is cause? Well, if you're terminated with cause, then it has to be serious misconduct, okay? Such as dishonesty, harassment, insubordination, not listening to your employer at all, not showing up to work, or more recently, off-duty conduct. So what do they have to do? Well, an employer should provide progressive discipline, some type of performance improvement plan, and warnings to try to show that your job is in jeopardy. If the employer does not do that, then you can fight the fact that you were terminated with cause. Because if you don't know that what you're doing is wrong, how can they subsequently assume and say that after the fact? And oftentimes the employer is wrong, because oftentimes the employer takes an English dictionary definition of cause, coming from the word because. for example, we are terminating you because you didn't listen to us. We are terminating you because you did this job poorly. That's not it. In employment law, cause has an extremely high threshold. There are very specific things that have to happen for them to be able to do that. So that's why it's very important for them to progressively inform you that your job is in jeopardy. So what do they have to do? They have to prove that what you did was on purpose. They have to prove that what you did was severe. And they have to prove that terminating you was quite literally the only option. Oftentimes, they don't do any of these things. So what are some key things to remember? If and when you are terminated, speak to a lawyer immediately. Your employer will never offer you their best package, because why would they? Your employer may make your entitlements conditional, which, if you recall, cannot be done. And your employer may suggest you're not an employee at all. That's strange. Well, what if you were hired as an independent contractor, but you're working there full time? Kind of sounds like you're an employee, doesn't it? Well, if you're an independent contractor, your rights are probably less, and that's why they may want to focus on that. And the deadlines that are set in the termination packages are arbitrary. If, for example, you have a termination letter and it says get back to us in a week, it's not a real deadline. You can ask for an extension. There's no legal ramifications if you don't listen. What's important to note, though, is you have 2 years from the date of your termination to act on your rights, to try and get a lawyer, to try and fight for a larger severance package. 2 years. Not whatever 1 week, 2 weeks that they tell you that you have. And I highly, highly recommend, the only thing that a lawyer will ask you to do if you're terminated, apply to jobs and keep a record. The date that you applied for a job, the name of the company, the position you applied for, please just keep a record, and that'll ensure that it'll benefit you in the future. And the process is not as scary as you think. I know that maybe you guys have some sort of a conception of what a lawyer does or how court proceedings work from TV or movies, but it's really not. You more often than not, as a client, you get to sit at home, continue your life the way it is, and we're just negotiating in the background. So don't be nervous. And what are some common misconceptions? First of all, you are not obligated to receive a promotion, a salary increase, hour increase, shifts. A lot of times I speak to individuals where they say, but the boss told me I'll be getting a raise. But they don't have to do that. They can say what they want to say until it's actually written in stone, agreed upon. It's not real. It doesn't exist. So even if you work there 12 years, 20 years, you might deserve a promotion, but you're not obligated to receive one, and they're not obligated to provide one. And you do not have to accept a major change to your contract. You do not have to wait to apply for employment insurance. You are allowed to cash in your minimum entitlements. And you do not have to wait to apply for other jobs if you're on a layoff, nor do you have to inform your current employer. And lastly, you do not have to accept mistreatment. So, what are some resources that you could rely upon? Well, what we offer is quite a lot. We have employment law shows, we have radio, we're on YouTube, we have blogs, and many more. Now, with our employment law show, you can hear from the managing partner, Samfiru, who talks all about various examples and employment rights. And as you can see here, these are all the days and times where you might see this. And also, if you're driving, you can listen to it on the radio at all of these places, at all of these times. And if you've missed any episodes, well, you can watch them on our YouTube. Now, what most people make use of is the Severance Pay calculator. PocketEmploymentEmployer.com, SeverancePayCalculator.com, very easy website name to remember. If you go onto the website, you are able to see exactly what you are entitled to. Mind you, it's an estimate, but it's a pretty accurate estimate based on a wide array of factors. It's very simple. You click a few buttons and you have an estimate. Now, if you have a particular specific question, well, you can go on our website, terminationquestions.com, and you can give a specific question regarding your situation, and we'll answer it likely within the hour. Now, the last thing that I'll talk about is the contact information. So, as I mentioned, I am an employment lawyer here with Samfiru Tumarkin. I represent a lot of clients, and I've been fortunate enough to provide settlements for all of my clients that I've had, and all of them have been quite happy about it. You're welcome to see the Google reviews. You'll probably see my name a few times if you scroll through them. And if you want to know more about me, or if you want to contact me for a consultation yourself, either now or in the future, you're welcome to do so by any of these below contact points, via email, via phone. You could see my profile on the website, or you can join me and connect with me on LinkedIn. So aside from that, does anybody have any questions? Feel free to let me know. I will wait a minute or so, or 2 minutes.
Hi, Boris.
Yes.
Yeah, so I'm just coming on to say, thank you for the presentation. Yeah, definitely, I think that a lot of those points were super, super important for new immigrants to know, because, people come here not knowing what their rights are, what the protected grounds are. I was lucky enough to learn about these things in school here in Canada, but, many newcomers don't have that opportunity. So actually, thought it was really interesting that you touched on, the non-compete clause specifically, because that was something that happened to me. So that's pretty crazy, that I don't remember what it was, what the length was that you mentioned, but my non-compete clause was like a year. So I feel like at that point I'm like, wait a second, maybe that wasn't exactly legal.
Yeah, because think about it this way. Let's say you are specialized in one particular skill set, and now the employer says you can't work with a competitor for a year.
Yeah.
But then at the same time, they say that we're not going to give you a larger package because you're not applying to jobs.
Yeah.
But I can't. You said I can't because of the non-compete.
Yeah.
Right? So,
well, and actually, what's very funny, I was an independent contractor technically.
Yeah.
So that job was very, I think you've got a case there, so to say. Yeah. So yeah, definitely, a lot of these things people don't even think about. Like I didn't even think about it at the time, because I was like, oh, the pay is great, no problem. But it can impact you in the long run, again, like I was lucky enough that it didn't really make a difference in my career, but, like you said, if you specialize in a certain skill, or in a certain trade, for example, you have no other option but to work in that area. A non-compete clause can really damage your income. So again, yeah, Boris, thank you so much. And actually, another thing that I wanted to mention to anyone in the chat, like Boris mentioned, if you do have a concern that you want to address to your HR, there are protections in Canada, right, for people not being able to be like reprimanded just for submitting a concern to HR. So a lot of people I know, even at my old jobs, were nervous to go to HR about harassment or discrimination, that type of thing. But Canada does have protections in place for employees who do experience that kind of thing. So yeah, again, thank you so much for coming out today, both to you, Boris, and to our audience. So if you'd like, Boris, you can leave your contact info in the chat, and if anyone would like to reach out to Boris, please feel free to do so. But after this, right now, we've got one session running, which is how to land a six-figure job in Canada by Nada Buhengi. So that'll be in the sessions tab on the left. And at, I believe, 3:30, we have another panel coming up. So that'll be a panel of experts that are discussing issues relevant to immigrants to Canada. So that's it for this session. Again, Boris, thanks for coming out, and I'll sign off for now.
Thank you. All right. Take care, guys.
All right. Have a great afternoon. Bye-bye.